Committee will come to order. Without objection, the Chair is authorized to declare a recess of the subcommittee at any time, and without objection, members of the full committee who are not members of this subcommittee may participate in today's hearing for the purpose of making an opening statement and questioning the witnesses. The title of today's subcommittee hearing is the Department of Justice's Operation Choke Point. The Chair now recognizes himself for 5 minutes. In the spring of 2013, the Department of Justice launched what's known as Operation Choke Point, representing an expansive investigation of banks and payment processors with the objective of combating consumer fraud by choking out fraudsters' access to payment systems. This committee values the Department's procedural methods of proficiency, identifying and prosecuting fraudsters, and it appreciates its effect on our economic prosperity as well. However, equally important to the federal prosecution of alleged fraudsters are lawful methods by which the government and regulators identify and investigate those in question. For any division of government to seemingly circumvent lawful, judicious means of conducting federal investigations, it not only subjects itself to rigorous congressional oversight, but it also betrays those who it seeks to protect, and that's the American people. Directly contacted from enterprises and individuals, Congress has learned that after Operation Choke Point's onset, various lawful businesses were identified and notified that their bank accounts were being terminated. When these legitimate enterprises inquired about the sudden termination of their accounts, their banks expressed that it was a result of, quote, regulatory trends or, quote, heightened scrutiny, end quote, and explicitly denied any negative review of the account holder's financial risk. Upon receiving copies of account termination letters from targeted merchants, members of Congress questioned why banks had explainably used the cliched teenage breakup excuse, "It's not you, it's me." In the last year, to comprehend how Operation Choke Point's targets were identified and how banks were getting mixed up, members of this committee and of the Oversight and Government Reform Committee here in the House have written letters to regulators and requested documents from the Department of Justice. From the committee's experience, the Department of Justice initially attempted to block congressional oversight and investigations of Operation Choke Point. But the DOJ has since provided 854 pages of internal memoranda, email communications, and presentations that have provided some detail of its investigation. The initial findings are quite disturbing. Rather than directly investigate merchants for fraudulent activities, the Department of Justice subpoenaed banks and payment processors of targeted merchants to effectively compel them to choke off businesses from accessing the banking system. Consequently, it seems that Operation Choke Point may have led to banks terminating their relationships with unjustifiably named, quote, high-risk, end quote, merchants out of fear of civil and criminal liability from the Department and other financial regulators as well. Equally as troubling, Operation Choke Point's regulatory approach of employing an axe rather than a scalpel and informal operations suggest it as another iteration of this administration's game plan to circumvent the rule of law and Congress to achieve ideological objectives. Even worse, the Department of Justice and FDIC have blocked the committee from meaningfully understanding Operation Choke Point by failing to provide details about the program, and financial regulators have even misled this committee as to the breadth of their cooperation when engaging with banks. Even with this much established, the irony is that the full role of financial regulators in Operation Choke Point remains a mystery. That's why we have this hearing today. But then again, what a congressional inquiry has made clear is that this administration and financial regulators have raised serious concerns of collaborated effort to facilitate an ideological crusade against industries profiled by the government through their abusive threat of launching federal investigations. This is not the intent of the rule of law in our system. The Department of Justice may have originally advertised Operation Choke Point as an honorable, authentic investigation to combat consumer fraud. Yet, unfortunately, congressional investigations have begun to uncover the questionable legal authority of Operation Choke Point, inappropriately compelling banks to serve as the moral compass and law enforcement for our market economy. This raises serious questions about the motives of and threats issued by the Department of Justice and financial regulators. It's my hope that today's witnesses assist this committee in better understanding the truth of Operation Choke Point by revealing the demonstrated actions of the Department of Justice and FDIC to determine whether lawful businesses were indeed victims of an objectionable government operation. I'll now recognize the gentleman from Texas, Mr. Green, the ranking member, for his opening statement.
Thank you, Mr. Chairman. I thank the staff for the outstanding job it has done in providing us with intelligence. I'd like to also thank the witnesses for appearing today. Mr. Chairman, we live in a world where financial and technological innovations present greater access and convenience for the American consumer. Unfortunately, this also provides the doer of fraudulent deeds greater opportunities to perpetrate crimes on consumers. In 2013, the Automated Clearinghouse processed approximately 22 billion transactions worth about $38.7 trillion. As innovative technologies evolve to benefit consumers, innovative methodologies must also evolve to protect consumers. Fraud detection and prevention methodologies are good for both consumers and businesses. Undetected fraud can bankrupt a consumer and put a business out of business. Today, we will examine the relationship between banks, their business associates known as processors, and consumers. And in so doing, I think it appropriate to use at least one very elementary example so as to give some clarity to persons who may be watching who are not familiar with this process. Typically, with a simple example, we would find that a person sitting at home is approached by a business that would like to have a person make a purchase. Let's assume that this is a telemarketer. This telemarketer will present the consumer with a product. If the consumer makes a purchase, that purchase is handled by a processor. A processor would be the company that works with the telemarketer. The processor receives the payment. The processor will then take the payment and deposit it in a bank. That bank then becomes the means by which the payments are paid to the telemarketer. And once these payments are made, let's assume that the consumer concludes that there has been an overcharge. A chargeback can occur. The chargeback is called to the attention of the bank. The consumer gets redress. The question becomes this: is a bank required, or should a bank be required, to keep a record of chargebacks? And if the record is maintained of chargebacks, would one incident of a chargeback indicate anything more than a mistake? But if 10,000 chargebacks occur, would that indicate activity? And if activity occurs, should activity be investigated? And if activity is investigated and is found to be fraudulent, should the bank have some responsibility if it knew that the activity was occurring but did nothing? There are serious questions to be answered. I believe we have capable, competent, and qualified witnesses here today who can help us answer these questions. The question also occurs as to whether or not a bank has a duty to perform due diligence as it relates to the business associates it has who are doing business with other businesses. And if it does have the requirement to perform due diligence, can that due diligence be outsourced to a processor who does business with a telemarketer? And if it is outsourced, are there consequences associated with it? What level of due diligence must the processor employ? Does it have the same level of due diligence placed upon it as the bank? And can a lack of due diligence by a processor in some way impact the liability of the bank that it's doing business with? We really should take a close look at these questions, and we really should examine the difference between an incident and criminal activity. One occurrence, an incident. Thousands of occurrences can be concluded to be activity. Should activity be investigated, and if so, should the banks provide intelligence such that the activity can be appropriately investigated? Mr. Chairman, I look forward to hearing the answers to these and many other questions from the witnesses that we have today, and I will yield back the balance of my time.
We'll now recognize the gentleman from Missouri, Mr. Lukemeyer, for 2 minutes.
Thank you, Mr. Chairman, for allowing me to participate today. Operation Choke Point takes a new approach to banking supervision. If you don't like a given industry, bend your authorities and force that industry out of the financial services space, making it impossible for it to survive. How does it work? The DOJ staff that conceived of Operation Choke Point summed it up in a November 5, 2012 memo to Mr. Delarey. Banks are sensitive to the risk of civil and or criminal liability and regulatory action. In other words, DOJ can intimidate banks into doing what it wants by threatening them with subpoenas, including with the regulators. Since last August, I've met with some of our regulators and even one of the witnesses on today's panel. In each of those meetings, the regulators agreed that casting a wide net and targeting legal industries is inappropriate. But despite that settlement, Operation Choke Point continues. I'm troubled that requests I've made for cooperation over the past year have fallen deaf ears. To that end, I've taken a step in trying to solve the problem by offering a bill, End Operation Choke Point Act, under which financial institutions will be granted the safe harbor necessary to serve legally operating customers. Keyword, legally operating customers. Equally important, the legislation will ensure that DOJ will not be able to act unilaterally in a broad brush approach in attacking legal industries. Mr. Chairman, I look forward to the discussion on what I can find to be an indefensible and irresponsible approach to regulation. I yield back.
We'll now recognize the gentlelady from Ohio, Ms. Beatty, for 2 minutes.
Thank you, Mr. Chairman and Ranking Member, and thank you to our witnesses today. You've already heard definitions of choke point. We've actually heard some thank yous to the department, and then we've heard the axe versus the scalpel. Well, today we look forward to hearing from you. And Mr. Chairman, I think this hearing is quite timely. We also know that we're on a parallel track with the Judiciary Committee, who's also looking at this. While Operation Choke Point is a fairly recent initiative undertaken, as you've heard, by the DOJ, designed to root out consumer fraud from the United States fiscal markets. I think today, hearing from you, we need to determine, if we go back in history when we heard we were too big to jail and we should do more to prosecute, and now we're hearing administration or Department of Justice is too overzealous. So here's where I am in my opening remarks. Each year, consumers, banks, merchants, and third-party payment processors conduct trillions of dollars of legitimate electronic transactions in a safe and efficient manner. Maybe because oftentimes the DOJ has applied the scalpel to it to make sure that things are tweaked so we're able to protect our consumers. Now, where I agree with the axe is there are bad actors, and they persist today. Unlicensed lenders make loans that violate state usury laws, or out-of-the-country websites may conduct unlawful online gambling rackets, just as an example. When banks or third-party payment processors facilitate automatic consumer bank withdrawals that enable unlawful activity to occur, it has a devastating impact on the lives of those consumers, our communities, and it also affects the good actors. This hearing is supposed to evaluate Operation Choke Point with an eye towards ensuring that business operate lawfully and are not denied access to banking services. Thank you, Mr. Chairman.
We'll now recognize our witnesses. Mr. Stuart Dellery is the Assistant Attorney General for the Civil Division at the Department of Justice. He was sworn as Assistant Attorney General on August 5, 2013, and has led the division since March of 2012. As the Assistant Attorney General, Mr. Dellery oversees the largest litigating division in the Department of Justice. Mr. Dellery joined the Department of Justice in January of 2009 as Chief of Staff and Counselor to the Deputy Assistant Attorney General, later served as an Associate Deputy Attorney General, and then prior to that, he served as Senior Counselor to the Attorney General. Mr. Dellery graduated from Yale Law School and the University of Virginia. Mr. Richard Osterman is currently serving as acting General Counsel for the Federal Deposit Insurance Corporation. Mr. Osterman is the Deputy General Counsel for litigation and resolution of branches in the legal division of the FDIC. The branch provides litigation counsel for the FDIC and comprehensive legal support for the FDIC's resolution and receivership functions. Mr. Osterman has served as Assistant General Counsel for the General Litigation Section, which includes appellate litigation, so on and so forth. And prior to that time, he was Assistant General Counsel for the Receivership Operations and Litigation Sections, which, as we know, has been a busy time during that era. He has a BA from Swarthmore College and a JD from the University of Baltimore School of Law. Mr. Daniel Stepano is the Deputy Chief Counsel in the Office of Comptroller of the Currency. He served as Acting Chief Counsel from October 2004 to August 2005. As Deputy Chief Counsel, Mr. Stepano supervises the OCC's enforcement, compliance, litigation, community and consumer law, and administrative and internal law divisions. He also supervises the OCC district counsel staffs in the OCC's southern and western districts. Quite a busy portfolio he has. Mr. Stepano received his JD from the Marshall Wythe School of Law at the College of William and Mary in 1983. He also received a BA degree from the Union College in 1980. And finally, Mr. Scott Alvarez is the General Counsel for the Federal Reserve Board. Mr. Alvarez joined the board in 1981 as a staff attorney and became a senior attorney in 1985. In 1989, Mr. Alvarez was then appointed to the board's official staff as the Assistant General Counsel and was named Associate General Counsel in 1991 and then became General Counsel in 2004. He's had quite a distinguished career at the Fed, and he's worked with board members and senior staff to develop policies and legal positions on domestic banking issues. He's been responsible for legal analysis relating to bank acquisitions and mergers. He earned a BA in economics from Princeton University in 1977 and a JD from Georgetown University Law Center in 1981. Thank you for coming back before our subcommittee. You all are familiar with the lighting system. Green means go, yellow means hurry up, red means stop. You'll have 5 minutes to summarize your opening statements. I would just counsel you, these microphones are very directionally sensitive. They're the best of modern technology from 2 decades ago, so please use them appropriately and bring them very close to your face and mouth. We'll now recognize Mr. Dellery for 5 minutes.
Thank you, Mr. Chairman. Chairman McHenry, Ranking Member Green, and members of the subcommittee. Thank you for inviting me here today.
If you'll pull the microphone closer
certainly,
to you.
For providing
awkwardly close to you, please.
That is.
Thank you.
That certainly is close, Mr. Chairman. And thank you for providing me and the department the opportunity to describe our work that's designed to protect consumers from fraud perpetrated by certain merchants, third-party payment processors, and banks. The Justice Department has made it a priority to fight consumer fraud of all kinds. Fraud against consumers comes in many forms, from telemarketing fraud to mortgage fraud, from lottery scams to predatory and deceptive online lending, and often strips our most vulnerable citizens of their savings and even their homes. The Civil Division's Consumer Protection Branch along with the Criminal Division and the United States Attorney's offices across the country, has worked for decades to protect the health, safety, and economic security of the American consumer. Based on its years of experience in combating fraudulent merchants and by following the flow of money from fraudulent transactions, the Department has learned that some third-party payment processors, which are intermediaries between banks and merchants, know that their merchant clients are engaged in fraud and yet continue to process their transactions in violation of federal law. Further, our experience in these cases has been that some banks, in violation of the law, either know about the fraud that they are facilitating or are consciously choosing to look the other way. As a result, in November 2012, our attorneys proposed a concentrated effort to pursue the fraud committed by the banks and payment processors as a complement to the other consumer protection work that we're doing. This strategy aims both to hold accountable those banks and processors that violate the law and to prevent access to the banking system by fraudulent merchants. This effort is sometimes referenced as Operation Choke Point. One of our investigations has now been resolved and provides a useful example of our work in this area. In April, a federal district court in North Carolina entered a consent order and approved a settlement agreed to by the Department and Four Oaks Bank. According to our complaint, Four Oaks allowed a third-party payment processor to facilitate payments for fraudulent merchants despite active and specific notice of fraud. For example, Four Oaks received hundreds of notices from consumers' banks, including statements by account holders under penalty of perjury, that the people whose accounts were being charged had not authorized the debits from their accounts. Four Oaks had evidence that more than a dozen merchants served by the payment processor had a return rate over 30%, a strong sign the bank was facilitating repeated fraudulent withdrawals. Indeed, one merchant had a return rate over 70%. Four Oaks also had evidence of efforts by merchants to conceal their true identities. So according to our complaint, despite these and many other signals of fraud, Four Oaks permitted the third-party payment processor to originate approximately $2.4 billion in debit transactions against consumers' bank accounts. As the Four Oaks Bank case demonstrates, the Department's policy is to base its investigations on specific evidence of unlawful conduct. Nevertheless, in recent months, we've become aware of reports suggesting that these efforts instead represent an attack on businesses engaged in lawful activity, and I thank you for this opportunity to clear up this misconception. Our policy is to investigate specific unlawful conduct based on evidence that consumers are being defrauded, not to target whole industries or businesses acting lawfully, and to follow the facts wherever they lead us in accordance with the law, regardless of the type of business involved. Now, as with virtually all of our law enforcement work that touches on regulated industries, our work in this area includes communication with relevant regulatory agencies. Such communication is designed to ensure that we understand the industry at issue and that we have all the information we need to evaluate enforcement options in light of the evidence we uncover. That is nothing new. And for many years, banking regulators have warned banks about the heightened risks to consumers associated with third-party payment processors. In some of that guidance, FDIC has explained that although many clients of payment processors are reputable merchants, an increasing number are not and should be considered high risk. And the FDIC has provided examples of high-risk merchants for purposes relevant to its regulatory mission. The Department's mission, however, is to fight fraud, and we recognize that an entity simply doing business with a merchant considered high risk is not fraud. So in summary, our efforts to protect consumers by pursuing fraudulent banking activity are not focused on financial institutions that merely fail to live up to their regulatory obligations or that unwittingly process a transaction for a fraudulent merchant. But when a bank knows it's willfully ignorant to the fact that law-breaking merchants are taking money out of consumers' accounts, we will take action. So thank you once again, and I look forward to answering the questions that you and the members of the committee.
Mr. Alvarez, you're recognized for 5 minutes.
Chairman McHenry, Ranking Member Green, other members of the subcommittee, thank you for the opportunity to testify about the Federal Reserve's supervisory activities relating to banking organizations and their account relationships. The Federal Reserve believes it is important that banking organizations provide services to consumers and businesses whose activities comply with applicable law. It is equally important that banks do not facilitate or participate in illegal activity. To this end, Congress, through the Bank Secrecy Act, requires banking organizations to establish and maintain programs designed to detect when services provided by the organization are being used for illegal purposes. Under the BSA, Federal Reserve regulated institutions, like other depository institutions, must have an effective program for knowing and performing due diligence on their customers. Importantly, banking organizations must identify and report known or suspected violations of the BSA and other federal laws, including reporting suspicious transactions related to money laundering activity. Criminal prosecutors at the Department of Justice and other law enforcement officials have direct access to the database that holds these suspicious activity reports and use this information to initiate investigations. The Federal Reserve and the other federal banking agencies have published an examination manual intended to provide practical and flexible guidance to examiners and banking organizations regarding acceptable customer due diligence and risk mitigation practices as part of an effective BSA program. Banking organizations are expected to have a risk assessment program that takes a number of factors into account in the review of customer relationships, including the standards the customer has in place to ensure compliance with applicable law and the relationship that the customer seeks with the banking organization. The purpose of these policies is to ensure that banking organizations provide services to law-abiding customers. The decision to establish, limit, or terminate a particular customer relationship is a decision for the banking organization. It is not the board's policy to discourage banking organizations from offering services to any class of law-abiding financial services customers. Many of the questions that have arisen with respect to the customer due diligence expectations of the federal banking agencies relate to the involvement of non-banks as intermediaries or providers of financial services, including money services businesses and third-party payment processors. Money services businesses provide financial services such as check cashing, money remittance, and similar payment services. Some MSBs include large, globally active companies, while others are small businesses such as gas stations and convenience stores offering financial products and services. By comparison, third-party payment processors are bank customers that provide payment processing services to merchants and other entities such as telemarketers and online businesses. Both MSBs and TPPPs engage in transactions with individuals and companies who are not direct customers of the bank. The Federal Reserve follows an interagency examination manual and guidance issued in 2005 by the federal banking agencies and the Treasury's Department of Financial Crimes Enforcement Network governing account relationships with MSBs. That guidance confirms that banking organizations may provide banking services to MSBs that operate lawfully. The Federal Reserve also follows the Interagency Examination Manual and related guidance issued by FinCEN when evaluating the procedures banking organizations use to manage account relationships with third-party payment processors. The objective of this guidance and the Federal Reserve's supervisory activities is to direct banking organizations to take appropriate steps to offer their services to legitimate and law-abiding customers and to minimize the risk of facilitating money laundering, terrorist financing, or other illicit activity. Finally, Operation Choke Point is an initiative of the Department of Justice. The Department of Justice has the sole authority to indict or seek criminal fines or other sanctions and to criminally prosecute individuals and businesses for their actions. As we have testified previously, the Federal Reserve cooperates with the other agencies in various enforcement actions, including by providing information in response to subpoenas and other requests issued by the Department of Justice and the other federal law enforcement authorities. Thank you for the opportunity to present the Federal Reserve's view on these important issues, and I'm pleased to answer any questions you may have.
Mr. Osterman, you're recognized for 5 minutes.
Good morning, Chairman McHenry, Ranking Member Green, and members of the subcommittee. I appreciate the opportunity to testify today on behalf of the Federal Deposit Insurance Corporation on the FDIC's supervisory approach regarding insured institutions establishing account relationships with third-party payment processors. I also will discuss the FDIC's interaction with the Department of Justice's Consumer Fraud Initiative, Operation Choke Point. As the primary federal regulator of state-chartered financial institutions that are not members of the Federal Reserve System, the FDIC is responsible for supervising these institutions for adherence with safety and soundness standards, information technology requirements, the Bank Secrecy Act, other anti-money laundering laws, and consumer protection laws. The USA Patriot Act, enacted in 2001, added new due diligence requirements for banks under the Bank Secrecy Act and requires banks to establish and maintain a customer identification program. The purpose of the program is to enable banks to form a reasonable belief that they know the true identity of each customer. It is, in its most basic form, knowing one's customer serves to protect banks from the potential liability and risk of providing financial services to an unscrupulous customer, and also to help protect the general public against illegal activity, including terrorist financing and money laundering, since banks are a common gateway to the financial system. The vast majority of transactions passing through financial institutions and payment processors are legitimate and initiated by reputable merchants. However, certain kinds of businesses, transactions, or geographic locations may pose greater risk for suspicious or illegal activity. Where transactions from a customer or merchant client of a bank's third-party payment processor customer are not legitimate, there is a real risk for the bank because it can be held legally responsible for facilitating those activities and transactions. Harm to the bank can range from operating losses attributable to unanticipated consumer reimbursements to civil or criminal actions for facilitation of violations of law. As challenging as it can be for financial institutions to understand the risks involved in activities of a direct customer, the difficulty is magnified when the activities involve third parties. Third-party payment processors may have relationships with numerous merchant clients for which they initiate transactions. As the financial services market has become more complex, the federal banking agencies, FFIEC, FinCEN, have issued additional guidance on several occasions alerting financial institutions to emerging risks and suggesting mitigation techniques. Most recently, in September of last year, the FDIC issued guidance that clarifies and reminds institutions of the agency's policy and supervisory approach. It states that financial institutions that properly manage relationships and effectively mitigate risks are neither prohibited nor discouraged from providing payment processing services to customers, regardless of the customer's business models, provided they're operating in compliance with applicable state and federal law. The FDIC reemphasized this policy to address any confusion that may have existed about our supervisory approach. We have reiterated this policy to our bank supervision managers and examiners to ensure that they are following this policy. In early 2013, the FDIC became aware that DOJ was conducting an investigation into the use of banks and third-party payment processors to facilitate illegal and fraudulent activities. The FDIC has a responsibility to consider the potential risks such activities could pose for safety and soundness of our institutions. We frequently coordinate with other agencies in supervision of our institutions. Accordingly, FDIC staff communicated and cooperated with DOJ staff involved in Operation Choke Point based on an interest in DOJ's investigation into potential illegal activity that may involve FDIC-supervised institutions. FDIC attorneys were performing their duties as lawyers for the agency in furtherance of the FDIC's mission. In conclusion, our supervisory approach focuses on assessing whether financial institutions are adequately overseeing activities and transactions they process and appropriately managing and mitigating risks. We're not focused on particular businesses. Each bank must decide the persons and entities with which it wants to have a customer or business relationship. Financial institutions that properly manage customer relationships and effectively mitigate risks are neither prohibited nor discouraged from providing payment processor services to customers, regardless of the customer's business models, provided they're operating in compliance with applicable laws. Thank you, and I'm happy to respond to the committee's questions. Thank you.
Mr. Stefano.
Chairman McHenry, Ranking Member Green, members of the subcommittee. Thank you for the opportunity to appear before you today as the subcommittee reviews the Department of Justice's Operation Choke Point investigation. I have spent over 20 years working on Bank Secrecy Act and anti-money laundering issues.
If you'll pull the microphone.
Yes, sir. And have witnessed many cases where banks have been used.
That's no better, sir. If you'll try again.
Okay.
Closer to your face.
All right. I'm going to put it right up there. I've spent over 20 years working on Bank Secrecy Act and anti-money laundering issues and have witnessed many cases where banks have been used, wittingly or unwittingly, as vehicles for fraud, money laundering, terrorist financing, and other illicit activities. Ensuring that banks have strong systems and controls in place to deter these abuses is an important objective of the OCC's supervision. The OCC is not part of Operation Choke Point, so my testimony today will focus on the OCC's supervisory policies and actions. However, it is our policy to cooperate with law enforcement investigations, and the OCC routinely receives and processes requests for information from law enforcement agencies. Some of the official requests for information we received from DOJ during 2013 were related to Operation Choke Point. As the subcommittee is aware, the OCC's primary mission is to charter, regulate, and supervise national banks, federal savings associations, and the federal branches and agencies of foreign banks. In carrying out this mission, the OCC requires banks to appropriately manage their risks, meet the needs of their communities, comply with laws and regulations, and provide fair access to financial services and fair treatment to customers. The safety and soundness of an institution, indeed its very viability, can be threatened when a bank lacks appropriate risk management systems and controls. I have seen firsthand the serious consequences for a bank and the public when these controls are missing. A 2008 OCC enforcement action against Wachovia Bank illustrates this point. Wachovia failed to properly oversee activity in its third-party payment processor accounts and ignored significant red flags indicating consumer harm. Telemarketing customers of the payment processors deliberately targeted vulnerable populations, such as the elderly, for the sale of products of dubious or no value. The telemarketers used high-pressure sales calls to convince these consumers to provide their personal checking account information. Payment processors then used consumers' account information to create checks that were deposited into the payment processors' accounts at the bank. The bank received hundreds of complaints, and hundreds of thousands of the checks created by the payment processors were returned. Despite these red flags and clear knowledge that consumers were being harmed, the bank failed to properly address the situation. As a result of these failures, the OCC cited the bank for unsafe or unsound practices and unfair practices in violation of the FTC Act and required it to pay approximately $144 million in fines, restitution to consumers, and other relief. The OCC did not, however, require the bank to cease doing business with any third-party payment processors or telemarketers. Rather, the OCC's action was focused on requiring the bank to remediate specific consumer harm and to establish enhanced risk management policies in order to mitigate the risk of future harm to consumers. Currently, there is great concern that banks are terminating the accounts of entire categories of customers, and some have suggested that regulators are dictating these actions. As a general matter, the OCC does not direct banks to open, close, or maintain individual accounts, or recommend or encourage banks to engage in the wholesale termination of categories of customer accounts. In rare cases where the bank cannot properly manage the risk presented by a customer, or a customer has engaged in suspected criminal or other illegal activity, we may order the bank through an enforcement action to terminate the customer's account. We expect banks to assess the risks posed by individual customers on a case-by-case basis and to implement appropriate controls to manage their relationships. We recognize that the controls banks put in place to manage their risks are matters of banker and supervisory judgment. If the bar is set too high, it can cause banks to terminate accounts of legitimate businesses. However, if the bar is set too low, the consequences can be dire, allowing the bank to be used to facilitate criminal and other forms of misconduct. At the OCC, we strive to take a supervisory approach that is reasonable, balanced, and fair, and results in systems and controls that are effective in deterring the use of our nation's financial institutions for illicit purposes. Thank you again for the opportunity to appear before the subcommittee today, and I will be happy to answer your questions.
I thank the panel, and I begin with a slide on the screen. If you all take a look, and as I give you some context, this PowerPoint slide was presented at a September 2013 conference by financial regulators in the Department of Justice for third-party payment processors. As you can see, this list, it says high-risk merchants / activities. Included on that are firearms sales, ammunition sales, and other lines of business. In essence, this is a government hit list of industries telling banks to sever ties with these merchants from these industries. So who created this list? That's what I'd like to ask the panel. Mr. Dellery, did the Department of Justice create this list?
Mr. Chairman, no, this is not a DOJ list.
Okay. Mr. Osterman, did the FDIC create this list?
Chairman McHenry, the list was actually first came up in the context of a Supervisory Insights Journal article that was written back in, I believe, 2011. And
did the FDIC create this slide for the 2013 Third-Party Payment Processors Relationships Conference?
I think that slide would have been on the, I believe it was the slide that was used during the conference by an FDIC individual.
Okay, okay, by the FDIC. Okay. So to that end, why did the FDIC pick out these particular industries for banks to consider as high risk?
So it's interesting because, as I said,
it is interesting, but please tell me why.
Sure. Actually, it's drawn from the industry itself. I mean, we were asked to provide examples of high-risk activities, merchant categories associated with high-risk activities, so banks and institutions could know where they needed to do heightened due diligence. And it's really drawn from situations where you're dealing with highly regulated entities where certain things may be legal in some states, not legal in others, or where some things are prohibited. You have higher incidents of complaints and chargebacks.
Yeah.
So it's based
Mr. Spano, to
drawn
ask,
from the industry.
So you as well have are a prudential regulator.
Yes,
do you have a similar list? Does the OCC use a similar list for targeting industries?
No.
Okay.
We do not tell banks who to do business with. Our issue is making sure that banks have systems and controls in place to manage the risks that are posed.
So that's a case-by-case basis?
Well, no. We would expect all banks to have systems and controls to manage their risks.
No. What I'm saying is you'll target fraudsters on a case-by-case basis, not based on a full industry, locking them out from financial services.
Yeah, I think that's
okay.
accurate.
Thank you. And so to continue this questioning, I'd go back to Mr. Osterman. And do you see the divide here? You could see you put out this list, and it says don't do business. That's what the banks have heard. Don't do business with these full lines of industry.
Right, and
isn't that problematic?
It's certainly been misinterpreted, and that's why we put out guidance in September saying we're not saying to banks you can't do business with any entity. It's up to you to do business with whoever you want. These industries, these merchants have been identified by the payments industry as entities that have been involved in high.
To that end, and Mr. Dellery, you can flip through the binder in front of you, tab 15, just so you have context for your email. 2 months after this presentation, you were told that some banks are exiting high-risk lines of business, and I'm quoting from you that email of talking points given to you. Does the Department of Justice use this list in Operation Choke Point?
Congressman, as I indicated before, our investigations are focused on specific instances, specific evidence of unlawful conduct based on evidence that consumers are being defrauded, not participation.
I hear you, but I'm asking a question about the email before you that you received on talking points related to Operation Choke Point. It uses the same terminology here, high-risk merchants, to describe banks exiting that full industry. Is that the Department of Justice's stance?
Right.
If it's no, that would be helpful. If you just say no, that's not the Department of Justice's stance, I think that would be a satisfactory answer if it is in fact true.
Yes, and Congressman, no, that is not the Department's stance, and we have taken steps in response to concerns that have been raised to make clear to the public and to industry that we are focused on evidence of particular fraud by financial institutions.
So the fact that you're given talking points that use the exact same terminology from this PowerPoint presentation targeting these industries is merely a coincidence.
Congressman, I would need to go back and look at the context for this, but what I can say is that our policy is to, again, focus on fraud where banks and financial institutions are knowingly facilitating fraudulent transactions or deliberately looking the other way. We are not interested in the participation in any particular industry, and participation in a lawful business has not been a factor in deciding on any of the subpoenas, for example, that I have authorized.
We'll now go to the ranking member of the full committee, Ms. Waters, for 5 minutes.
Thank you very much, Mr. Chairman. But I'm not thanking you for holding this hearing. In my estimation, this is a little bit ridiculous and a waste of time. Let me thank our witnesses here today for doing your job. This is exactly what some of us expect you to do. I want you to know that many of us are aware of activities that are fraudulent, that are being perpetrated on the most vulnerable in our society. Oftentimes, you have the poorest communities who are the victims of many of these schemes and fraudulent activity. So I'm very, very pleased about Operation Choke Point. I want you to be as aggressive as you can possibly be. A point of contention is how the operation is being conducted and what methods the Justice Department is going about gathering information related to fraud. Can you just once and for all repeat to the legal authority justice is using in FIREA to help protect vulnerable consumers? Is there anything new or unique about the investigative or procedural methods being used in Operation Choke Point? Where does your authority come from under FIREA? What would the effect be of amending FIREA to restrict the department's authority to bring these kinds of cases? How else do you use FIREA? What other examples or cases can you give where FIREA has been used? We just don't understand why anybody would think that you would target legal, lawful businesses. I mean, that would be a waste of time. It would prove nothing. So could you just please relate to some of the points that I'm asking Mr. Dellery?
Yes, thank you, Congresswoman. I'd be happy to respond to some of those points. On the question of legal authority, FIREA is a statute that prohibits fraud against affecting federally insured financial institutions. It's a powerful tool that the Department uses in a wide variety of contexts to prevent fraud in the financial system and to maintain the integrity of the financial system. So just yesterday, for example, the resolution that was announced with respect to Citibank, the $7 billion resolution, was based on FIREA. So it's a powerful tool that we use in a variety of contexts. This set of investigations flows from our longstanding work targeting fraud against consumers of all kinds. There's an endless variety of scams that affect consumers, and probably all of us know a family member or neighbor or coworker who has been victimized by consumer fraud. One thing that many scams have in common, though, is the need for access to the banking system in order to get the money out of consumers' accounts. And so by following the money from the investigations of fraudulent merchants, including the Wachovia case that Mr. Stepano mentioned earlier, our lawyers and our investigative partners realized the roles that some payment processors and some banks were playing in knowingly facilitating fraud. Seeing red flags of fraud, hundreds of complaints, return rates 30, 50, 70%, demonstrating repeated fraudulent transactions. And so as a complement to the work that we do to target lottery scams and telemarketing scams of all kinds, we have focused these cases on banks and financial institutions that are knowingly participating or deliberately turning the other way when they see red flags of fraud. We believe that that's illegal, and the Department is committed to pursuing that just as we are committed to pursuing other types of fraud.
And I thank you for your work. And I was just reading about the $7 billion settlement with Citibank. Whether we're talking about Citibank or any of the other banks, HSBC, et cetera, OCC, you know I have a bill on money laundering. And we know that it is, if I have any criticism at all, is that, yes, the fines are bigger, but it's not enough. Somebody needs to go to jail. Somebody needs to go to jail on some of these schemes, on money laundering, and some of the other kinds of high-risk activities that you have listed here. So I don't want you to be intimidated by this hearing today. I want you to work at this. I want you to go harder at it. And Justice Department, let's put somebody in jail for the pain and the suffering that some of our consumers experience based on some of these schemes and this fraudulent activities. I yield back the balance of my time.
We'll now go to the Vice Chairman of the Subcommittee, Mr. Fitzpatrick of Pennsylvania.
I thank the Chairman for calling the hearing, and I want to associate with some of the remarks of my colleagues that are also concerned with changing constitutional standards, such as a presumption of innocence, which is a bedrock of our rule of law, sometimes using federal regulators or perhaps pressuring federal regulators to achieve ideological objectives of the administration. Mr. Dellery, I'm looking at a memo, and I think it's tab number 2 in the documents before you, dated September 9, 2013. The subject or reference line is Operation Choke Point 6-month status report. And in that memo, the Department of Justice stated that in the event that a legitimate business was innocently harmed by Operation Choke Point, it should be left to the legitimate lenders themselves to prove that they're innocent. Does this mean that you're guilty until proven innocent?
No, Congressman, that is not.
Let me rephrase it then. Is it common practice at the Department of Justice generally, and in your division that you oversee in particular, to take the approach that if the entities that we're investigating are legitimate, that it's up to them, those entities, to prove it?
No. I think no, and that's not what is happening in this context either. If I could explain a little bit about how we came to identify the institutions that we're investigating, I think that would be helpful. And this really involved the use of standard law enforcement techniques. So we got information from confidential informants. We got information from complaints that banks had made or that customers who had been defrauded had made.
Mr. Dirlo, you're discussing entities you're investigating, but is it possible when you create or somebody creates a list of whole industries and then you pressure regulators to eliminate or terminate processing relationships, payment relationships with those entities, that legitimate law-abiding businesses in this country that employ Americans can be hurt, will lose those relationships, and perhaps could lose their business? Is that possible? When you use a broad brush?
Congressman, again, I think that this is not a situation that involves the use of a broad brush, but I do think that we take seriously the concerns that have been raised by members of Congress and that we've heard from industry, and that's why we have committed to taking steps to make clear to the public and to industry groups what our policy is, that we are investigating specific unlawful conduct based on evidence of fraud against consumers and not entire industries. So we have written to industry groups, we've met with industry groups to make clear what we are or are not doing, and that is something that we will continue to do, because I agree, Congressman, that it's important that people understand the scope of our law enforcement activities, and why I'm happy to—
Mr. Dellery, you just responded a moment ago to the ranking member that this really is about following the money. That's what Operation Choke Point is about. So let's follow the money here. Mr. Dellery, what is the Department of Justice 3% fund?
The 3% fund is it's a fund that's, as I understand it, established by statute, and that a certain 3% of recoveries from certain types of cases are put into the fund and can be used for other law enforcement activities.
In other words, the Department of Justice gets a portion of the settlements obtained from initiatives like Operation Choke Point. Is that correct?
I would have to, I'm not sure of exactly which types of cases lead to recoveries that contribute to the 3% fund. It's not everything that we do, but certainly a portion of our affirmative work.
Can you respond back to this committee in writing within a reasonable period of time as to whether or not cases settled through Operation Choke Point contribute to the 3% fund?
Certainly, we can get back to you on that.
The American people need to know more about how the Department of Justice financially benefits from these settlements, so you'll commit that you'll provide us with full financial disclosure. Is that correct?
I mean, certainly we'll answer the question about to the extent that the department gets or the Treasury gets a penalty in connection with these cases, whether any part of that goes into the 3% fund. I just don't know.
And you'll provide that disclosure back to the genesis of the point where Operation Choke Point was created, all the way back to the beginning?
Certainly we can. You're asking about particular amounts. We can see if we can do that, certainly.
Yield back.
Now recognize Mr. Cleaver for 5 minutes.
Thank you, Mr. Chairman. Are any of you familiar with the Electronic Transaction Association?
Congressman, I recall when we were here the last time, I think it was Chairman McHenry had indicated that the ETA had put out some guidance in this area.
Yes, they put out guidance because they were concerned about rooting out fraud in the system. Is that your understanding?
Yes, sir.
Okay. So now this high-risk merchants activity list that we have seen, this is what I'm assuming the American banker used when they wrote the story about this new or what is perceived to be this new operation that is now underway. Is this your understanding of how that story got started?
I think there's certainly been a lot of discussion about that list of examples and the concern that entities are being targeted, which is simply not true, which is why we put out a guidance that says that.
But now if the ETA, the Electronic Transaction Association, did the same thing, except they are inside trying to suggest to their to the banking world some cautions. I mean, it's essentially the same thing, right?
Well, I mean, as we've said, that list is not a list that we made up. It's actually drawn from the industry itself. It's where examples of situations where there have been high chargebacks and consumer complaints and illegal activity.
So, Mr. Stefano, do you have any idea how long the OCC principles regarding risk management have been in place in terms of dealing with bank payment processors?
Yes, sir. They go back to at least the mid-1990s.
Yeah, I would. Yeah, I guess I'm trying to figure out why all of a sudden something that began back in the 1990s without question is now worthy of congressional hearings. I think Lone Ranger, Ren 1010 are all involved now. So what has happened to cause this to surface? Was it that this was printed someplace, or what has happened?
I would suggest that partially what has happened is an evolution of the financial system. We've seen the growth of the internet, we've seen telemarketing, and so we've seen this just mushrooming of various entities that are trying to get access to the financial system. And as a result, we're seeing more fraud. Yeah,
but the point I'm making, perhaps poorly, is that this has been going on since the I think it's the early 1990s. The same things we've been talking about on this committee, they've been going on since the 1990s. There's been an acceleration because of what you just mentioned with the advent of the Internet. So I don't understand. If anything, we ought to have a greater understanding about Treasury and Justice and other agencies trying to make sure that consumers don't get hurt any further. Am I way out there? Am I wrong, anybody? No, I didn't think so. The U.S. Consumer Coalition, a new organization, has just pledged $5 million to fight this whole process here. And I'm not sure who they are. I wish we had somebody here from their organization to explain why they're spending $5 million to fight federal agencies trying to protect consumers. That's just a question that floats out there. I don't expect anybody to answer it. I yield back the balance of my time.
We'll now recognize Mr. Fincher for 5 minutes.
Thank you, Mr. Chairman. I was curious as we were getting ready for the hearing today, and I appreciate all of you guys being here, where the term choke point came from. And the first thing is I looked up the definition. It's a term used for military strategy where a geographical feature such as a valley, bridge, or straight through which an armed force is forced to pass is used to greatly decrease its combat power. Mr. Delray, I apologize.
Delray, thank you.
Delray. Where did choke point, why did you use, where did this come from, and why not call it Operation Sunshine instead of choke point?
So Congressman, the name was the name that the career lawyers who proposed this set of cases gave to the operation, and I think it refers to the fact that in order to obtain money from consumers' bank accounts, fraudulent merchants need access to the payment system.
I have a memorandum here, November 5th, 2012, from Joel M. Sweet to you, talking about Operation Choke Point. And I guess before I start, the point I'm trying to make is, this isn't rocket science, but it seems like this was political from day one with a term like choke point. You're choking, you may claim to be choking off the payday lenders in their business, but really you're choking off constituents and folks in my district. The payday lending industry supports 3,015 jobs in my state. As you may know, I'm from Tennessee, and the payday industry started in Tennessee. 2011, the Tennessee legislature passed legislation that creates one of the best payday lending industry regulatory systems in the country. Tennessee law prevents rollovers, caps the maximum loan rate at $500, and sets a maximum term of loan at 31 days. The Deferred Presentment Services Act, codified in the Tennessee Code, requires that all payday lenders be licensed regardless of the manner of service delivery, including the Internet. In 2012, the Tennessee State Legislature passed reforms that required all online lenders to be licensed with the state. Additionally, payment instrument was defined to mean a check, draft, warrant, money order, traveler's check, or other instrument for payment of money, whether or not negotiable, and also includes any authorization for electronic payment of money. Mr. Delray, what is the state of Tennessee? What are they doing wrong that the Justice Department felt the need to step in and protect the consumers of Tennessee when it's clear the state has gone to great lengths to do so and is getting it right?
Congressman, as we have said publicly on a number of occasions, we are not investigating businesses that are acting in compliance with state law. And I think that the Four Oaks case that I mentioned earlier is maybe the best example of what we are looking at. And in that case, there were particular fraudulent merchants who were engaged in deceptive.
Do you have any other cases beside that one that you always refer to? Give me another example.
Well, I think two others would be the First Bank of Delaware case from 2012, which I think illustrates this point.
You have more than three, all right?
And Wachovia. We have other ongoing investigations, but those are the ones.
Do you know there have been more complaints in Tennessee, consumer complaints against financial services industry? There have been more complaints against the banks than there have against the payday industry, loan industry.
I was not aware of that, Congressman.
I guess my question is, I'm from a district that the median income is about, I guess I've got it right here, I better make sure I get it right, $45,000, something like that. And this fills a gap. The average loan was like $229. That banks can't make any more because they've been regulated to the point, because of Washington, that they can't make these small dollar loans and make any money on them. So this industry has filled a gap for people, for single moms, for people that are struggling to make it from week to week. And it seems like from day one, from choke point, just think about it, folks, choke point, that this has been an assault, not on the payday industry, because the trickle-down, as we all know, doesn't touch the payday lenders. It ends up hurting my folks at home, my constituents. So as we go forward here, my time is up, let's be very clear what the intent is. And one day, you may be just trying to regulate soft drinks as well, that we can't have too big of a soft drink. A government that's big enough to give it to you is big enough to take it away from you. I yield back, Mr. Chairman.
We'll now recognize Ms. Maloney for 5 minutes.
Thank you, Mr. Chairman and Ranking Member, and thank you to all of the panelists today. And I particularly am glad to see Mr. Alvarez. It's rare that you appear before this committee, so I want to take the opportunity to clarify an issue that's important to the constituency that I represent. And I refer to the Fed's interpretation of the Collins Amendment on insurance. And that interpretation, which I understand was yours, referred to the federal governors, was that it did not give the Federal Reserve the discretion to tailor capital standards for the large insurance companies that it regulates. I'd like to ask you about a bill that recently passed the Senate that addresses this portion of the so-called Collins Amendment. And do you think that the language in the Senate bill 2270 solves this problem? In your opinion, do you think that it gives the Federal Reserve discretion to tailor capital standards for insurance companies?
Thank you, Congresswoman. It's good to see you again. As you stated, the Collins Amendment puts a floor on the Federal Reserve and the other banking agencies' ability to tailor capital requirements, and requires that the minimum capital requirements for all bank holding companies, including insurance companies that own banks or insurance companies that own savings thrifts, as well as anybody designated by the FSOC as a significant as a SIFI, all of those institutions have to have capital at least at the level that would be the minimum level for a bank. The bill that's passed the Senate does specifically allow the Federal Reserve to adjust that capital requirement for a company engaged in the business of insurance. And the Federal Reserve will follow whatever the directive is of Congress. If Congress chooses to have a floor that's the bank floor, that's what we'll follow. If Congress chooses to have more flexibility for insurance companies, that will be what the Federal Reserve will do.
Well, thank you for that clarification. And I have a series of other questions that I'd like to present in writing for you to get back to the committee, because I have other questions of other representatives here today. I'd like to ask Mr. Del Rey, as the prior speaker indicated, there seems to be a lot of confusion about the scope of Operation Choke Point. Can you comment on this? Is Operation Choke Point a DOJ task force, or is it a novel enforcement method that the Justice Department is using? How would you describe it? What is it? Is it a special project? What is Operation Checkpoint?
Thank you, Congresswoman, for that question. I think the short answer is Operation Choke Point is a set of investigations that were designed to investigate evidence of fraud in the banking system that facilitates fraud against consumers. That's what it is. It's using established legal authorities. Fraud has been illegal for a long time. It uses ordinary law enforcement techniques to identify the institutions that need to be investigated, like complaints from banks, complaints from consumers who have been victimized, information that comes to light in investigations of fraudulent merchants that suggests that banks and payment processors were knowingly participating. So we have taken evidence that we received through standard law enforcement practices and have
And this has been going on since the 1990s, the prior speaker said?
Well, so I think that was a reference to guidance about the risks in the payment system that the regulators have provided. But this particular set of cases arose out of cases in several years ago.
Thank you. And I'd like to ask Dan Stepano. You said in your testimony that in the Wachovia case, the bank had ignored significant red flags indicating that consumers were harmed, besides a high number of chargeback rates. Can you describe what some of these red flags were?
Yes, Congresswoman Maloney, I'd be happy to do that. But I would like to start with the chargeback rate because they were excessively high in the Wachovia case. They were in excess of 50%. But besides that, other red flags would include customer complaints, for example, law enforcement inquiries, and also where the money is going. If there are large volumes of payments that are heading offshore, that is sometimes a red flag.
Are there different red flags for different types of bank customers?
They can, I think, vary depending upon the nature of the business involved, yes.
Jolie's time has expired.
Thank you.
We'll now go to Ms. Wagner of Missouri for 5 minutes.
Thank you, Mr. Chairman. And I thank the witnesses for being here. Mr. Dellery, a major concern with Operation Choke Point is that it harms legitimate businesses. Mr. Fincher just talked about the thousands of jobs that have been lost in Tennessee. I have also heard from business owners from across Missouri and Kansas, the whole entire region, that say they have had to cut thousands of jobs because of Choke Point. How would you respond to those concerns, sir?
Well, thank you for the question. I appreciate the opportunity to respond directly. I think I'd respond as we have been responding when these concerns have been raised, which is to make clear that our investigations are about particular evidence of fraud by particular organizations, not industries or businesses acting lawfully. And we've attempted to communicate that to the public and to business in a number of ways. But I think it's important not to lose sight of what's at stake here for consumers, because consumers, when they are the victim of a fraud, face devastating situations when their bank
accounts are drained. Excuse me. So just so that I understand things, are you saying that DOJ is dedicated to ensuring that Operation Choke Point does not harm legitimate businesses?
Absolutely. Certainly in the exercise of
Mr. Dellery, did you receive a memo from your Consumer Protection Branch addressed to you entitled Operation Choke Point, 6-month status report dated September 9th, 2013?
I believe that I did.
You did?
Yes.
The report which I have here says, and I quote, "Although we recognize the possibility that banks may have decided to stop doing business with legitimate lenders, we do not believe that such decisions should alter our investigative plans." Is this, sir, DOJ policy?
As I indicated before, our policy is to make clear that we are not targeting lawful businesses, and that's what we've done.
But wait a second here. Yes. But then in your testimony here today, you said, sir, that DOJ is dedicated to ensuring that its efforts to combat fraud do not discourage or inhibit the lawful conduct of honest merchants. Yet, at the peak of Operation Choke Point, in a memo sent to you, your lawyers recognized that legitimate businesses were in fact being harmed, but decided that the ends justified the means. Are you saying, sir, that DOJ's policy has changed?
No, Congresswoman. I think if you look at the overall context of that document, it makes clear that the goal of the—
So DOJ policy has not changed? You are still targeting legitimate businesses?
No, Congressman. Our policy from the beginning of the framing of these cases and to today, which we have restated publicly, is that we are pursuing evidence of
but your own lawyers have said something completely opposite to that in terms of collateral damages and going after legitimate businesses in a sense that I guess you have to break a few eggs in order to make an omelet. I mean, what is your response to that, sir? There seems to be great disparity here.
I think that if you look at the materials that have been provided, you'll see that the policy and the framing of the cases was clear from the beginning. If you look at even that one as a whole, that document makes clear that the cases were about fighting fraud.
Mr. Sellery, clearly the DOJ's public statements to Congress do not match with its internal communications. What will you do to restore the integrity to your office and ensure that no more legitimate jobs or businesses become collateral damage, so to speak, of Operation Chokeport?
Well, I think what I will do is what I have done since these concerns have been raised, which is to re-articulate the policy to the public and to the industry and internally to make clear that our investigations are focused on evidence of specific unlawful conduct that we're investigating based on evidence that consumers are being defrauded, not entire industries.
Sir, are the thousands of jobs lost across the country from Missouri to Tennessee just collateral damage to the Department of Justice?
I don't view any consequences as collateral damage. I think, I mean, obviously we take seriously the need to make clear what we are and are not doing.
Well, you haven't made it clear, sir, because your internal communications are completely different than your testimony here today. So I'm asking you, has DOJ policy changed regarding this?
DOJ policy from the beginning, my policy, which I have articulated publicly and internally, is that these cases are about fighting evidence of fraud, not conduct of lawful businesses. And I will continue to maintain that policy, and I expect that the managers and supervisors of these cases will make sure that it is implemented.
Mr. Chairman, I believe my time has expired.
Mr. Delaney? I'm sorry. Ms. Beatty is recognized for 5 minutes.
Thank you, Mr. Chairman and ranking members. We've heard a lot of questions poised in pretty much the same vein. Certainly as we've been listening today, and we know that Operation Choke Point, carried out by the DOJ Civil Division Consumer Protections Branch, is a series of investigations and enforcement acts which are designed, most importantly, to protect the American consumer from mass market fraud. Given that, and I'll start with you, Mr. Dellery, and the questions that you've been attempting to answer, let me try to put it in a different vein. What, if any, evidence is there that Operation Choke Point may be having a deterrent effect on consumer fraud in the United States?
Well, certainly I think that that's the hope that we have for our law enforcement work in this area and otherwise. We, by investigating evidence of fraud, as reflected, for example, in the Four Oaks case, when we announce a resolution of a case like that and detail the allegations and the evidence that we have related to fraud facilitated by a financial institution, our expectation is that that will have a deterrent effect. We hope that the Citibank resolution that was announced yesterday has a deterrent effect on fraud against investors. We hope that our cases involving tainted food and medicine have a deterrent effect so that other sellers don't make people sick. And in this context, we hope that there's a deterrent effect for consumer fraud. As these cases continue, we'll be looking for that.
Let me follow up with, because we've heard a lot about the third-party payment processors and that process. Does the DOJ bring claims against third-party payment processors or financial institutions that, let's say, unwillingly or accidentally facilitate fraudulent or unlawful activities? And if not, kind of outline or describe for us how you can be sure of that?
Okay. Thank you, Congressman. Congresswoman, I appreciate the opportunity to address that because I do think it's an important issue. Our cases are focused on knowing participation in fraudulent activity by merchants, so that the bank or the payment processor has information like exorbitant chargeback rates that were discussed earlier, or sworn complaints from hundreds of customers, or evidence, as was the case in the Four Oaks case, evidence that the merchants were hiding their identities, were not disclosing their true identities, or again in Four Oaks, complaints from a state attorney general about the conduct. So we're dealing with knowing information, not a technical violation of regulatory guidance or the unwitting processing of a particular transaction. Our subpoenas and our investigations are targeted at that kind of evidence, and we move forward with investigations and with actions where we can establish that that was the case.
And lastly, we've been hearing a lot of questions by some of my colleagues that, from where I'm sitting, sounds like that you are willingly going after people who are lawfully doing what they're supposed to do. So I'm sitting here trying to figure out what would you gain by having the DOJ go after people who are lawfully operating to put them out of business. So with that in the back of my mind, are there any statements you'd like to make to respond to those allegations that the DOJ's investigatory practices are designed to put good companies out of business?
I think the best way for me to respond is to say that that is not what we're doing. And the indicator of that, best indicator, I think, are the cases that we've actually brought. So the Wachovia case that has been discussed in great detail, extensive evidence of actual fraud by the financial institution. That's true for the Four Oaks Bank case that I've discussed, another case called First Bank of Delaware from 2012. So I think if you look at the track record of the cases that we have brought, they demonstrate that we're investigating fraud against consumers, which is the goal of this work. The goal of this work is to make sure that the hard-earned money in the bank accounts of consumers is not drained by fraudulent merchants with the cooperation of a financial institution. That's what these cases are about.
Thank you very much. Thank you, Mr. Chairman.
We'll now go to the gentleman from Wisconsin, Mr. Duffy.
Mr. Deleary, would you just walk me through the process and how you decide when to issue subpoenas for fraudulent activity? And if you could do it quickly, that'd be wonderful.
I'm sorry, how we decide on the... Certainly, I think it's based on standard law enforcement approaches. So looking at information that we have obtained in one investigation that suggests that another party is involved in law enforcement activity.
You investigate, you get complaints, and you make a determination that there's potentially fraudulent activity, right?
And then continue, to seek more information if that makes sense.
And then when you have enough information, you send a subpoena to the banks, correct?
Yes, when we have reason to believe that there is fraudulent activity.
So when you have reason to believe, you send a subpoena out. Right. And is it pretty fair to say, Mr. Osterman, when these banks receive a subpoena from DOJ that they cease to do business with the third-party payers or with the payday lenders? Is that fair to say?
I don't know that that is fair to say. I mean, I can't speak for the banks, but the subpoena is asking for documents. If the bank is operating lawfully and the third-party payment processor is acting lawfully, they have nothing to be concerned about.
Okay, great.
So why they wouldn't continue to do business.
Subpoenas are brought. You continue your investigation. You've referenced, 3 cases that you've brought a suit against banks, right? Four Oaks, one of them?
Four Oaks, yes, is one of them.
So I'm interested not in, because you keep talking about, fraud in the banking system, fraudulent merchants. Are you bringing cases at the DOJ against the fraudsters? Are you bringing cases against the third-party payers? You're bringing cases against the payday lenders?
So I think...
No, that's are you bringing cases? Answer my question. Are you bringing cases against the third-party payers and the payday lenders?
We are investigating.
No, so you haven't brought cases against them. That's my point. So listen, you have come in here and you've said, listen, we have fraudsters. They've committed fraud. Who has determined fraud? You're an attorney at the DOJ. Has there been due process? Has there been a hearing? Has there been an adjudication of fraud? No. You've come in here and said, we've got fraudsters across the country that we're protecting America from. There's no judicial determination of fraud. It's that we have a bureaucrat in the DOJ that says, I think it's fraud. And so, you know what? I'm going to shut down a legitimate business. Am I wrong?
Yes, Congressman.
Tell me.
I disagree with that summary of what we're doing, and I think
so. So then the question is, how many dispositions have you had from a court that these third-party payers or a payday lender has committed fraud? How many?
So a number.
How many?
I believe that
the answer is 0, isn't it?
I think no. In connection with the Wachovia case, the third-party processor was also.
You don't even know. This is you prepared how long for this hearing, and you can't tell me how many have been adjudicated fraudulent. And you've come in and you've told us with a straight face and a straight eye, there is fraud, and I'm protecting the American people. Listen, I'm going to put up the list of high-risk merchants. So you can go after payday lenders, which, listen, there's no love for payday lenders, but the system that you're using is of concern. You can go after payday lenders. You might say, well, listen, high-risk merchants, they include firearm dealers, they include ammo manufacturers, right? You can go after all of them to protect the banks. And so can Mr. Osterman at the FDIC. I think I was listening, and we heard that highly regulated industries that do business across state lines or have different regulations in different states. Another one that could be on this list, if administrations change, could Planned Parenthood and could the abortion issue be on that list? I'm not saying it should, but who's to say that they couldn't fit in to a bureaucratic scheme to shut down legitimate business? I look at Colorado. You have the DOJ bending over backwards to make rules work so drug dealers selling marijuana can actually bank. But here on the list, you have tobacco sales as high-risk merchants. Our concern is we have a federal government that's out of control, and we have bureaucrats who think they can get a swift idea and impose the heavy-handed government on legitimate businesses that have had no adjudication of fraud, but you come in here and you say fraudulent, 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 and you haven't proved it at all. I yield back.
Gentleman from Washington, Mr. Hack, is recognized for 5 minutes.
Thank you, Mr. Chair. I want to also thank the gentleman from Wisconsin for the seamless segue to my line of inquiry. Mr. Osterman, I had intended to ask you about Operation Choke Point, but then last night with my 12-hour-old edition of USA Today, I opened it up, and there on page 1 was an article that was entitled, "Pots of Marijuana Cash Cause Security Concerns." Among other things indicated in this article, a security expert saying about marijuana businesses in states where it's been legalized, either for medical use or for adult recreational use. Some people walk in with shoeboxes full of cash. Some people walk in with locked briefcases. We've had people bringing in buckets. The vast cash flows are a clear come-on for criminals. And finally, you're effectively creating a magnet for crime. I've been very concerned about this public safety issue for some time. That's why I was pleased last August when the Department of Justice did, in fact, in the now famous Cole Memorandum, set forth its conditions for standing down in prosecutorial action. Remind you that the two top criteria are preventing marijuana from getting into the hands of children and preventing cash from getting into the hands of gangs. And was followed in February of this year, a wonderful Valentine's Day, by guidance from the Financial Crimes Enforcement Network, in which they indicated the basis on which they would not seek follow-up action. Both of these effectively create I guess, kind of a safe harbor if the terms and conditions are followed. In the spirit of those terms and conditions, I think, although there are many, with the Department of Justice, it's those 8 terms and conditions, and with FinCEN, it gets into the suspicious activity reports and what reporting requirements are required. But the essence of them, really, is public safety. The essence of them, and I'm going to repeat myself because I think it's so very important, is to keep marijuana out of the hands of children and keep cash out of the hands of the gangs and the cartels. Mr. Osterman, you stopped short in your follow-up and implementation of this. And I guess my question really is, what, if anything, can you say today to give confidence to banks and credit unions that they can provide banking services to legitimate, legally constituted, legitimate marijuana businesses without the threat that your agency will penalize them, threaten their deposit insurance or whatever, or force them to close their accounts, keeping in mind that this is first and foremost a public safety issue?
Well, Congressman, the Cole Memorandum, which you reference, as well as the FinCEN guidance, I think is very helpful. And we have actually told our examiners to, when they're examining institutions, to ensure that those institutions are in compliance with those guidelines. And we have actually provided a letter to Washington State banking authorities to that effect. And I believe we may be in the process of doing that with Colorado as well.
It's the very letter that I'm referring to, Mr. Osterman, that does not go as far as the Department of Justice nor FinCEN's guidance in terms of basically saying, if you completely respect these terms and conditions according to DOJ and according to FinCEN, and again, for the third or the fourth time, the essence of which is public safety, keeping marijuana out of the hands of children and cash out of the hands of gangs and criminals, then you will not pursue regulatory action. Your letter stops short of that. What can you say today, or what follow-up correspondence might you be willing to provide that is consistent with the Department of Justice's language and form of safe harbor, as well as FinCEN's?
Well, I think, again, FinCEN, these are criminal activities. FinCEN sets the standard, and they've spoken. And I think we've gone, as far as I am aware, that we can go. If there were any kind of guidance that would be issued, it would have to be a interagency type activity through FFIEC. And I mean, I don't understand why that doesn't provide.
So are you saying that if they follow FinCEN and DOJ, you will not make a regulatory sanction?
We're telling our examiners to ensure that they're doing that. If they are, we're not going to.
I'd appreciate it if you would have them communicate that more clearly. Thank you, Mr. Chairman, for your indulgence.
The gentleman's time has expired, and while it's bipartisanship, it's two sides of the same leaf, perhaps. We'll now go to Mr. Barr of Kentucky for 5 minutes.
Thank you, Mr. Chairman. Gentlemen, I don't know of anyone who would find fault with financial regulators who, in good faith, are attempting to stop consumer fraud. I think what the American people are troubled by, what members of Congress are concerned about here today, is the prospect of powerful federal agencies working with the Department of Justice to pressure banks to terminate relationships with legitimate businesses. You can understand that. You can understand why there would be concern. And in particular, lawful and legitimate businesses that may be politically unpopular with this administration's policies. Let me give you an example of where a Kentucky resident raised this concern with me. And in Kentucky, we have particular sensitivity with the administration's what we consider a very political attack on a very legitimate business, the coal industry. We've lost 7,000 coal mining jobs in eastern Kentucky over the last several years because of this administration's regulatory assault against this very legitimate business that is employing thousands of people in our communities. We have these communities littered with unemployed coal miners, and their families are suffering as a result of administration policy. And so we get an email from a Kentucky resident in our congressional office, and this is what it says. Our family company has been in the business of leasing our land to coal producers for decades. Today I returned a call from client services at our bank in Lexington, Kentucky. They asked if we lease land to coal producers that operate surface mines. They said they are receiving pressure from bank regulators and will no longer do business with us if we have surface mines on our property. After some thought, I called back again and asked if we would be receiving a letter from the bank stating the situation in writing. I was told that yes, we would receive a letter, but it would not talk about pressure from regulators. Further, she said it would state to the effect that it is in the best interest of the bank not to do business with our company due to the perception and its effect on their business. So verbally, the bank is telling the customer, the regulators are pressuring us to not do business with your family any longer. But in writing, they won't do that. So my question to you all, as regulators and as the Department of Justice, are you aware of any guidance, directives, or efforts by your agencies to stop financial institutions from transacting business with coal operators or land holding companies that lease their land to coal producers? And I'll just have you all go down the line.
No, Congressman.
No, Congressman.
No, Congressman.
No, sir.
Okay, and so have bank regulators at any time in the last 2 years ever had a policy of pressuring banks to reevaluate their relationship with a coal operator, a coal production company, or a surface mining operation that you're aware of? Have you ever been in meetings where the topic of coal production has ever come up in the context of Operation Choke Point?
No, Congressman.
No.
Okay, and so I'm glad to hear that, because I want to get a commitment from each of you that you will assure me that your agency will not in the future discourage either explicitly or implicitly any financial institution from doing business with coal mining activities, whether surface or deep mine. Can you give me that commitment?
Yes, Congressman, as I've explained our policy, it would have nothing to do with the situation that you're describing.
So, Congressman, I agree with the notion that you're trying to bring across about dealing with an industry. I can't say that there isn't going to be some coal, an individual supplier that may not have financial difficulties where a bank may choose not to be involved with them because of that. So, putting aside the kind of credit quality and other kinds of normal banking criteria, I agree with you.
I think Mr. Alvarez has stated it appropriately. I mean, we do have underwriting standards that the banks would be looking at, and safety and soundness standards, but given the context that you're raising this, I agree with you.
And I only have 10 seconds left. I just want to make sure that when you're looking at fraudulent activity, you're not defining a risky business. You're not targeting risky businesses in a way that is in any way advancing the EPA's agenda.
No, Congressman. We're looking at fraud against consumers.
Thank you for your commitment that you will not further the war on coal. Thank you. I yield back.
And the record will note soft sighs of no, or still noted as no in the record. We've talked enough about the microphones, but they're quite lackluster. We'll now go to Mr. Kildee of Michigan.
Thank you, Mr. Chairman. And I want to thank the witnesses for not only your testimony, but for the work that you've been doing in protecting the American consumer, which, after all, is sort of the point of the activities that we're designed to get at here. I want to make a couple of quick observations and then ask for some commentary from the panel. Number one, I think we all understand political theater, and I have a sense that I'm participating unwittingly in a bit of political theater today. It's certainly not my intention, but that seems to be what's happening here. From questions about how the name was selected for this operation, I think somebody suggested Operation Sunshine. Next time you do this, maybe you should do Operation Powder Puff, and it might be not so offensive to some. Frankly, it's a ridiculous question, and I regret that you had to answer it. To a comment that, well, why are we worried about this? The average payday loan in one state is only $227. Well, you know, this is something that we've been looking at. I think about the case of the soldier who borrowed $1,600 and after 2.5 years had repaid $17,000 to the lender. So that $1,600 might not seem like a lot to some people in this room, but $17,000 for a $1,600 loan raises a bit of suspicion, and I think would indicate that there are some commercial practices, some entities, some enterprises, some areas of business that might be legitimately subject to scrutiny, and that's exactly what this is intended to do. So let me ask just quickly two things. One, there was much made of this slide, which indicates examples of commercial enterprises for which this sort of scrutiny might ultimately be applied. I would like whomever would like to offer a commentary on how a list such as this might be derived. Presumably, it's based on consumer complaints, return rates, real data that would lead one to conclude that if you're going to be looking for fraudulent activity, it makes sense to look at it where there's a greater likelihood that it's taking place. If you could just comment on that.
I'd be happy to respond. So this group of examples actually was taken from actual experience that the industry has actually had over the course of years. The problem that we've had is that it's been turned into something that it's not, right, which is you can't do business with these people, and that's why last year we issued guidance making it very clear that banks can do business with whoever they want to. They just need to have appropriate risk mitigation factors in place.
Thank you. I guess the other question that I would have is what your response is to this notion that there's an agenda behind this that is intending to sort of steer commercial or lending activity or banking activity away from one industry to another. And the implication that is being suggested is that because certain financial institutions may of their own volition decide that there's an area of enterprise that they have found to be problematic, that they make by themselves a market-based decision that they're going to move from that. Is that something that you're seeing in large numbers, number one? And secondly, is that an illogical conclusion for a financial institution to make, to say, well, I think we're going to sort of get out of financing activities in this category of, let's say, payday loans or gambling? Does it make sense to you that that might be a legitimate business decision that a for-profit enterprise might make just as a matter of course?
So I think that you know, these are business decisions that businesses make in terms of their risk tolerance and their underwriting standards. Again, it's a decision for those businesses to make. It's not for the government to make, and it's not one the government is making. All we're saying is some types of activities are higher risk, and you need to have appropriate risk mitigation measures in place.
I would just encourage all of you to continue to do the work you're doing to protect consumers, and I know you won't, but I encourage you to not take sort of the threat of political speech accusing you of trying to shut down legitimate businesses, which I know you are not, as an excuse to not protect consumers who clearly need the protection of their government. So I want you to continue your work in that effort, and I appreciate it. Thank you.
Chair recognizes Mr. Lukemeyer for 5 minutes.
Thank you, Mr. Chairman. Well, gentlemen, I appreciate the job that you do with regard to trying to root out fraud. Unfortunately, you know, what we've done today, Operation Choke Point, has gone well beyond fraud. It's gone beyond that. It now is, as we've heard this morning multiple times, going to an industry-based approach to try and get rid of everything and everybody in that entire industry versus only the bad actors in the industry, which is wrong. You know it's wrong. I know it's wrong. We discussed this, Mr. DeLaray and Mr. Osterman. We discussed this individually. And I thank you for the letters that we've received as a result of you trying to clarify your position that as long as the business is doing illegal business with legal entities, they're okay. But, gentlemen, we've got a problem. It's continuing. It has not gone away, has it? I can tell you, I can sit here this morning and give you case after case of what I've been talking about. I've got here in the paper, documented by the newspapers. Friday, May the 30th, there was a gun manufacturer in Hyannisport, Massachusetts. Here's one from 19th of May that talks about a firearms training and supply company in Florida. Here's Armory in Nevada. So, gentlemen, it's not a rogue agency doing this. It's not a rogue examiner. It's still going on now. What are you going to do to stop it? Mr. Osterman.
Congressman Lukemeyer, what we've done is we've tried to be very clear in putting out our guidance to say very publicly and clearly that as long as banks have appropriate risk mitigation measures in place, we're not going to prohibit or discourage them from doing business with anyone who they want to do business with. And we've said that. We've actually had meetings with our examiners. Our division directors have met with our examiners and sent that message to them. And we've sent that notice to the banks themselves and said, if you're aware of this happening, let us know.
Mr. Osterman, all due respect, you know and I know, as a former examiner, and you know it, that the banks are scared to death whenever an examiner comes in there and threatens them. Well, there is that problem. And I've talked to the bankers about this. And I said, okay, if they are telling you to do away with an entire book of business, which is going on, I said, have you asked them to put it in writing? And they said, yes. What did they say? And he said, the examiner refused to do that. So the examiner's not giving them the documentation to give you the track to go back to that individual. And as we see here, it's not going on in one state. It's going on across the country. This has got to be something that has got to be concerning to you if you're worried about this. If you're not, you know, I've discussed with Mr. DeLaray and you guys both about putting in place a safe harbor. Both of your agencies have denied wanting to work with us on that. The other day we had CFPB in here to try and ask them also if they would put together a safe harbor for the banks to be able to do business with legitimate customers that they've been doing business with for the last 25 years. I had a bank tell me he's had to get rid of a customer that's been with him 25 years. No reason other than the examiner said, hey, you can't do business with these guys anymore because they're in an industry that's under heightened scrutiny. So as a result of that, I offered a bill a couple weeks ago that's going to put in place a safe harbor. Would you guys be willing to support that? Mr. DeLaray.
Congressman, we certainly have seen the bill that you've offered. We're reviewing it, and we'll obviously continue to do that and work with you and your office on it. I think that what's important from our perspective is that we maintain the tools that are necessary to fight fraud against consumers. We have attempted in
well, you know, to that effect, we want to work with you, but you haven't been able to work with us. You haven't been honest with me. Mr. Osterman, are you willing to work with us on the safe harbor? How come we haven't got together yet? You guys wouldn't give me one.
We would be willing to work with you.
Do you like my bill?
We have concerns. Frankly, there are difficulties in trying to create a safe harbor in terms of avoiding unintended consequences.
See, gentlemen, by the going around the corners here, what you're doing this morning, it gives me great pause. The fact that we're still doing this, and now you won't go along with the safe harbor. You're saying, well, we can't do this, can't do that. It tells me you're not willing to give up choke point. You're willing to continue to go out here and do a broad brush approach to get rid of the entire industry, and that's wrong. Mr. DeLaray, one more quick question. Gentleman who was in charge of putting choke point together, Mr. Joe Sweet, is that correct?
He was the author of the original proposal, yes.
How come he was reassigned?
I obviously need to be careful about talking about individuals in this setting, but it's been reflected in the documents that he was in Washington on detail from his home U.S. Attorney's office. He's a career assistant U.S. attorney. He was here on a temporary detail that was 6 months. It was extended to a year, and when that ended, he went back to his home office, as was always the expectation he would do.
Interesting, it happened just a few days after we got the letter. Thank you very much. I yield back.
Recognize the ranking member, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, in court, we have an objection known as assuming facts that are not in evidence. Assuming facts that are not in evidence. Today, we have had a lot of anecdotal commentary given to witnesses, which would cause one to assume facts that have not been placed in evidence. We have not had empirical evidence of the allegations that have been made, the anecdotal evidence, if you will. So let's for just a moment examine some facts. Let's go to the North Carolina case, and let's talk for a moment about the number of complaints that were received against this bank. And I'll start with our representative from the Justice Department.
Well, as reflected in our complaint that was filed in the case when and then that led to the consent decree that the court approved, the bank had received hundreds of complaints from banks of customers who had been victimized that included sworn statements.
Let me intercede for just a moment. You said from banks of customers. So you have banks complaining about the activity of another bank.
Yes, exactly, Congressman.
And let's go on. From this material, these number of complaints, did the bank take some affirmative action without the Justice Department's intervention?
Well, again, as alleged in the complaint, the bank was aware of these complaints, as well as complaint from NACHA, the Payment Electronic Transactions Association, and the Attorney General of Arkansas, and yet continued to facilitate the transactions of the payment processor that was handling the transactions that were.
And let's put a face on this. These transactions were actually consumer purchases. Is that a fair statement? Or there were consumers associated with each of these transactions. Is that a fair statement? Because these were payday loans.
Many of them were related to payday lending, not all, but many, and they were transactions involving consumers. So the main complaint, again, as reflected in our allegations, was that the consumers had been misled into the terms and the number of debits that they understood would be coming out of their accounts.
And is it true, sir, that the bank received about $850,000 in fees associated with these transactions?
Yes, again, that's the number that we have in our complaint.
And is it true that there was a settlement for about $1.2 million, meaning that the bank agreed to pay some $1.2 million to settle this case?
Yes, and also agreed, as reflected in the consent order, to a series of compliance measures that we insisted on to ensure that fraud couldn't continue with respect to.
Was this a product of Operation Choke Point?
Yes, this was one of the cases, the investigations that arose out of that series of work.
If not but for Operation Choke Point, would we have the $1.2 million settlement? Would this bank have been put in a position such that it had to make a change such that this kind of behavior, this activity, is no longer continuing?
Again, Congressman, I think that result is the direct result of our work in these investigations. And this case is the best example of the kind of work that we're doing. It's about real fraud, not just doing business with a lawful industry.
Thank you. Let me quickly go to the, I'm going to call it the list of merchants. It's styled high-risk merchants activities. Now, it has been indicated to us that this list was compiled with the assistance of industry. Is this correct?
It's actually taken from industry experience, industry examples, and in fact, it's very
But this is about more than industry. This is about the people who were doing business with these industries. Is that correct?
Yes, yes.
Is it about consumers who were being defrauded as a result of doing business with these industries? Is that correct?
Well, again, as we've said in our guidance, the fact that certain industries are high risk doesn't mean they're
doesn't mean that they are that all of the businesses within an industry, but the complaints that are generated are usually based upon some consumer saying, you took too much money from my credit card, or you added too much to my credit card. You used my bank routing number, and you collected money from my bank without my consent and permission. Is that a fair statement?
Yes.
So we are trying to, with this, the intent of this was to protect consumers. Is that a fair statement?
It is, but again, I just would caution, that list does not
It's not yours.
Well, it is a list that came from a Supervisor Insights journal that FDIC published a long time ago, but the point of it was not to say you can't do business with these entities. A lot of those entities are legitimate.
I agree with you, but it's the purpose of it was to protect consumers ultimately.
Yes.
That was my question. All right, Mr. Chairman, if I may, I'd like to, for Mr. Heck, add the article that is styled Pots of Marijuana Cash Cause Security Concerns with unanimous consent, please.
Without objection.
And with this, I will yield back the balance of time that I do not have.
Thank the ranking member. With that, I'd like to thank our witnesses again for their testimony today. Without objection, all members will have 5 legislative days within which to submit additional written questions to the chair, which will be forwarded to the witnesses. And I would ask our witnesses to please respond as promptly as you are able to. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. And without objection, this hearing is adjourned.